that there seems to be in the community about the difference between a jail and a prison. All of us that have ever lived our lives within the criminal justice arena find it silly, but it's a reality that exists out there. And everybody always says ignorance is no excuse, but ignorance not being a bad word is definitely a reason why a lot of confusion happens, because we're so busy executing the laws of the state and our nation that a lot of times we don't find the time or put out the effort to educate the individuals that we serve on exactly what we're doing. So we had the jail experts come in, we had the sheriff of Fulton County come in, we had others come in and talk about it. And I want to be clear, our primary focus is the Fulton County Jail and the overcrowding there. And what we're trying to do is find out the reason, hopefully make some well thought out recommendations. And as we do that, go through the criminal justice system as it exists everywhere, but particularly how it exists in Fulton County, and look at all the components. Because we understand that the Fulton County Jail itself is, the sheriff is responsible for managing the jail. The county is responsible for funding the jail. The district attorney's office is responsible for prosecuting cases that go into and come out of the jail. And our judiciary is responsible for the due process and while protecting the rights of the citizens who are being held there in the Fulton County Jail. But again, we go back to the lack of knowledge that we all agree exists within the citizens who pay for the jail, who pay for the courts, who pay for the prosecutor's office, and who pay all the bills in Fulton County. And so we feel it's responsible, that we are responsible for educating those. And there are some nuances that kind of get lost in the shuffle. One of our guests today is the clerk of Superior Court. And in most cases, if I stop a citizen on the street and ask them what the clerk of Superior Court does, they're probably going to turn around and run because they don't know. But all of us understand the backbone within the court system in managing the records and the important things that have to be done in that office. And so I appreciate her being there. But we're going to start out today. I would love to tell you in no particular order, but there is a particular order because I do understand, and even though I have an attorney to my left, I do understand who could take a warrant out on me pretty easy. And that's the Chief Judge Glanville with the Fulton County Superior Court. And so I would ask Judge if you would come forward. And Judge, what we're asking for is an education on the role of the Superior Court here in Fulton County. Also, the what responsibility the Superior Court has on the overcrowding that currently exists in the Fulton County Jail. And I understand if the court says that they have no responsibility, but there'll be questions, and we just want to try to work our way to a solution. So hopefully any wrinkles we find in any of those four stools, legs that we talked about, that this committee could hopefully assist Fulton County in addressing those problems.
All right, well, thank you for allowing us to come over and talk with you. Dialogue is always very important, Mr. Chairman and members of the committee. And today I brought with me, in addition to our clerk, Shay Alexander, I have my colleague, Judge Robert McBurney, who serves on the Superior Court with me, as well as we have our Chief Magistrate, Cassandra Kirk, and one of her magistrates, Todd Ashley, along with our clerk of court, I should say our court administrator, David Summerlin. So to be...
Can I stop you real quick? Would you be comfortable if Judge McBurney came up and sat with you?
Absolutely.
Because
absolutely.
yeah, because I'm sure a lot of our questions when it comes to the Superior Court, both of you would be the experts in there, and so...
Well, we'll try and answer as much as we can for you.
Yes, sir.
Just want to make a quick comment before we begin. I want to thank Your Honor for your incredible service in the military.
Thank you.
Over those many years, and your leadership, and I think the example you set for so many others who come through the ranks. all the way up to your level was truly extraordinary. So thank you for your service.
You're very welcome. I served for 35 years. I retired on the 1st of July of 2019. I started out as an infantry officer, was commissioned at the University of Georgia, and I managed to serve the rest of the service, my 31 years as an Army Judge Advocate, and the highest rank I held was Brigadier General. So it's been my honor to serve the citizens of the state in a dual role, both as a commissioned officer as well as a professional jurist for now the past 28 years. I've served 20 years on Superior Court and 8 years as a magistrate before I won an election in 2004. But thank you very much, Senator Alpers. But to the role of what a Superior Court judge, that was the first question you asked me, Senator Robertson, was we have 4 or 5 unique things that go to Superior Court, because we have a lot of classes of court in Georgia. But Superior Courts handle family law matters, divorce, and other types involving family law support, and other things that go along and touch the family. We also handle equity. So anything, if you're asking for a TRO, TPO, or any type of injunctive relief, the only place you can get it is Superior Court, because we are the court that handles that. We also deal with land and property. So when any type of entity wants to put up something in your neighborhood, we become very popular, because then the variances and the zoning go through our local communities and then wind up in our Superior Court. Then we also handle felonies, which is what most people are aware of. They come and we are the court that handles and tries the trial of felony matters. So those are the unique things to Superior Court. Now, to your question about how does the court play a role in the backlog, during the period of and coming out of COVID, the word is collaboration. So the people in this room, and the reason I introduced all of them is because we all have to work together along with our county governance to make sure that we can deal with issues involving the backlog. And I know you've heard from our sheriff and our other justice partners. But what I tell people is that you have to understand how a criminal case makes its way to us and what happens. I know you all understand the rest in the indictment process, but when Ms. Alexander creates a calendar for me and it gets published, that's the due process that gets us into the courtroom. But out of a calendar of 40, if I could just kind of explain it this way, criminal cases or even civil cases, but we'll take criminal cases, 90 to 95% of those cases are going to resolve. So if you got 40, 25 of those cases are going to plead. Then you're going to have about 5 cases that we have mental health challenges. So folks will either have undiagnosed mental health challenges, or they need to have an evaluation, or they're not taking their medication, or something to that like. So we in Fulton County started a competency court, which is run by Judge Ingram, and we're proud to say we just started that about 60 days ago to deal with those kind of issues. So you've got 5 or so people you're going to have of that 40 that fall in that category, which you have to kind of manage along with their unique challenges. Then you've got the issue of science. So 5 folks or thereabouts are going to come up with, Judge, we don't have the ballistics report. Judge, we don't have the sexual assault kit process. Judge, the GBI hasn't tested the marijuana. And
Judge, if I can interrupt real quick, how did you preference that before you started running through the evidence? You said science?
Yeah, science.
Okay, good.
Yeah, we call it the science. It's the science issue of what it takes to resolve a case.
Yes, sir.
Or the forensics. That's the other,
Forensics,
the
yes,
forensics. It's GBI.
Yeah, and part of our challenge is that if the state hasn't gotten those results back, they can't make an offer to the defense, and then no defense attorney worth their salt is going to entertain or plead their client or go to trial when science is missing. So those category cases, I have to go ahead and reset as well. And I'm sure you probably heard from our district attorney. She's got about a 2,000 backlog of those particular cases that are pending because of results are pending. So it makes it challenging to get or make offers on cases to go to trial, and some of those people may unfortunately be in custody. So that's a challenge that we have. And then you've got 5 or so cases that we'll try them. And with most of our cases, like with a homicide, it's going to take 5 to 10 days. So in the span of about a month, we net about 4 to 6 cases. We plead 25 or so, but the other 15 or thereabouts, I have to continually manage and roll and continue to do that. So that's part of how we play a role in kind of removing the backlog. But the challenges are unique because of some of the things that we cannot control. So my ask or suggestion is, if there's any way that we can put more resources to testing, or to give opportunities for our county to have a more robust testing system, we could move a lot of those cases a lot faster. I know our governor last year put a lot of money into the GBI for us to go ahead and for that to be done, but the GBI services the entire state. So, and to that, we are the biggest county in the state. We have almost 1 million people. We have 15 municipalities, and we're just different. The difference I'd like to highlight to you all is that even though we count our cases, and the AOC, Administrative Office of the Courts, does a formula on how we rank judges or ask for judgeships, and certainly we all follow that. Fulton is unique for a couple of different reasons. I just kind of want to point out to you that maybe some of you don't know. We are the court of original jurisdiction for any state agency appeals. So anything that is appealed out of any state agency comes to Fulton County. We also are the court of original jurisdiction for any cases involving our constitutional officers. We also are the court of original jurisdiction for MARTA. So we have, and then also we have more types of serious cases that I would submit than any other jurisdiction in the state of Georgia.
Judge, what's your definition of serious case?
Well, that's our gang, multiple defendant, RICO cases. And as you all know, I'm handling one right now. Judge Adams is handling the 61 co-defendant Cop City case, and we have several of our colleagues that are handling multiple 10 co-defendant cases. So, like for example, this particular year, I took that, since I'm the chief, I don't have a criminal caseload. I took that case that I'm trying right now, and that's the only case, in addition to one other, that I am dealing with at this point in time. And had I had a regular docket of like my other 15 colleagues, I would have probably been floundering. But because I've been doing this so long, I've been able to manage and do some other things. But it's been a challenge. So could we use another judge? Absolutely. It would certainly help out in the sense of our being able to serve our citizens better, and it certainly would allow us to cut into and try more cases in an efficient manner. But Robert, you want to add anything?
I just would add a gloss to this because Chief Judge is modest. On a ratio of cases to judges, we're in the top 10. That's what the AOC has to look at. They have to consider a murder is a murder is a murder, regardless of where it happens. And they attribute a certain number of hours to resolve a murder case. And it needs to be uniform. Otherwise, you can't really say we're equitably distributing judicial resources. The reality is, and we've made the pitch before to the AOC, but I appreciate their fidelity to uniformity, is things are more complicated here. This judge has a murder RICO case that has consumed a year of his time in court. That ties up lawyers, that ties up sheriff resources, it ties up a judge. Judge McAfee, whatever you think about the case he has, is in court all the time on a RICO case. He has a full criminal docket that he can't attend to. So there are defendants in jail who can't get in front of Judge McAfee because he's consumed by primarily that case. My colleagues who have these 10+ defendant cases that you don't find in other jurisdictions. That's a long way of saying all murders, all RICOs, all complicated cases aren't the same. And so that math of cases to judge doesn't necessarily show the impact that some of these cases have on our ability to move the jail population. The jail fills because of arrests, police, probation, etc. The jail empties because of dispositions, what judges do. And if this judge is stuck in one case for a year, other dispositions will slow down. The solution is, it's not a want, it's a need or a hope, is another judge.
But Judge, real quick, but we're not saying that that a possible solution to jail overcrowding is to decrease arrests, right?
Not at all. No,
Right.
sir. I'm just the very
Right.
simple formula, as I try to think about it,
Yes,
is
sir.
inputs to the jail are arrests. And my point is in no way, let's arrest fewer people. That's an exogenous variable. The court doesn't control that. You're arrested because there's a new crime, because more crimes, whatever. Our obligation is to accept that incoming flow and triage it. If it's a misdemeanor, our Solicitor General does an amazing job of quick
Right.
turnaround. If it's a armed robbery, if it's a murder, if it's a rape, that's a slow, sticky case. And my
Thank you.
point was simply, they're slower and stickier here because they're often more complicated. And so there is an underjudging aspect to what we're encountering in Fulton County.
Yes, sir. Chairman Albers.
Yeah, thank you, Your Honors. This is very helpful, and one of the things we've been looking at, because I think this ties into the complexity part that you're talking about, is we're looking at the crime data based on who's using the gang statutes and prosecuting under those, and the areas that are, we're seeing a dramatic drop in the crime rate, because depending on which study, somewhere between 70 and 90% of all violent crimes are done by some type of a criminal street gang, these based on the data we've collected. And it seems to be that Fulton, as an example, is actually prosecuting on the gang statutes at a considerably higher rate than most other areas of the state are right now. So perhaps one of the takeaways, and I want to get your feedback on this, is when they're doing the analysis, as you've talked about, right, and they're following it through, maybe that needs to be added as the criteria, as part of the criteria.
That's a great idea. I know that they consider, it's not number of defendants, but at least the nature of the charge, and maybe there needs to be, we call it weight, there needs to be more weight put on any of the street gang offenses.
Thank you.
Thank you. Thank you, both of y'all, for being here today. Talking about potentially adding new judges, will you talk a little bit about what that looks like when it comes to the prosecutors that come with a new judge that we also fund by our formula, and also the public defenders, and how that would help with moving cases as well? Because you mentioned adding another judge, another docket, but can you kind of paint the whole picture as to how that would look when it comes to adding other players in the process too?
I don't want to,
Okay.
up to you, boss.
Basically, what it allows us to do is it allows us to spread out more work. Instead of there being 20 judges, you'd have 21 judges. And there are a number of us that do, like right now, of the 20 Superior Court judges in Fulton County, 14 of us do criminal. 4 do domestic relations, and that's it, because we have a family division. The chief doesn't have to carry a criminal docket, and that's because we have administrative responsibilities. But it's been the last couple of us that have held the position. We have had a criminal caseload and helped out from time to time. But what it would do is it would allow us to spread out even more of these cases to another judge and work them. It's just time over people.
Senator Strickland, to add to that, our DA's office has enjoyed unparalleled growth in the last few years because of ARPA funding and wise spending from the county commission. I have no concerns that they'd be able to staff a 21st judge. Our public defender's office has lagged behind in some of that funding, and so that's where we would need to ensure that we're growing that office as well. Because you can have a judge on the bench and a prosecutor right there, but 85 to 90% of our defendants are indigent, and so we need, it's two public defenders
Right.
per courtroom. So that would be the supplemental piece we'd need to work with our county on. I think they would be very supportive of the notion to grow that budget to support the framework of a 21st judge. But it is a package.
Right.
It's not just the judge. But I'm confident the district attorney's office could staff it. And we certainly would grow internally to support it administratively, and we happen to have an extra courtroom.
So based on your perspective, I know you can't speak for the district attorney, but you believe their office has the ability to staff another judge right now, and would be, obviously we got to make sure public defender's office is there. Is that your understanding, though, that they may be able to staff that?
I certainly do not pretend to speak for the elected official, the Madam District Attorney, but I'm quite aware of the hiring that has occurred since the pandemic. They're choosing where to deploy their resources, but in terms of headcount, it's not a situation where we'd be stuck with a prosecutorless courtroom.
Just one last question. Maybe last one, I don't know. Probably not. Do you, in your court, do you have a formula as far as how many, I use the word formula, it's probably too formal, but do you have a policy as to how many district attorneys you usually assign per judge? Is that the way it operates in your circuit right now?
That's up to our district attorney
Okay.
and her organization of the office. There are certain divisions that you'll see, depending upon what type of case you're dealing with, that will come in and handle that particular case.
Historically, back when I was an ADA, it was 2 line ADAs per courtroom. Under Paul Howard, and it's been expanded upon under DA Willis, that shifted to 1, what we call line ADA, who handles the burglaries and the basic cases, and then a host of specialized units, murders, different sex crimes, and of course there's a gang unit to handle the gang and RICO cases. So it's actually only 1 ADA who would be specifically assigned to Judge X, and then they need to expand the resources with the specialized units.
Okay, thank you.
And I thought the esteemed Chairman Strickland was reading my mind, but Judge, you said there were 14 criminal judges, 14 judges assigned to criminal right
Yes.
now? And what was the breakdown of the others?
It's four judges, I'm sorry, it's 15, it's 14, 50, I should say 15, 4, and then 1. So it's 15 actually. That math would, I'm sorry, my math is terrible.
4 is domestic?
4 do just nothing, they're in the family division.
Right,
So that's all they
and
do.
then the 1 is the chief?
Yeah, the chief, I have a civil caseload as well as I have administrative responsibilities, and so the chief,
So-
pursuant to our rules, doesn't carry a criminal caseload.
So looking at this, the chief judge, i.e. you, would be, you handle all civil cases?
I handle my share of civil cases that are spread upon, because all of our judges, except for the family court judges, we have a mixed docket, so we have civil
Okay,
and criminal.
and that's what I was trying to get to. When you say 15 judges assigned to criminal dockets, they also have civil cases on those
Yes,
dockets.
sir, they sure do.
When
Very
we-
much so.
When we were going through the COVID timeline, and not attempting to poke anybody in this building with a stick, but which I've been known to do in the past, everybody was talking about, we're cutting budgets, and myself and Chairman Albers and others were cautioning them about cutting within the court system. And I know Chairman Strickland was the tip of the spear on pushing for speedy trial relief and other things through that process, because we all understood there were many parts of government that could slow down, but criminal justice does not slow down. The constitutional rights of individuals to have their day in court is extremely strong. So doing that, we had the conversations that if a case has to lag, then civil cases have better opportunities to lag than criminal cases. And I've looked at other circuits, large circuits, that where you would have a certain number of judges that would just handle criminal cases, and then you would have judges that would handle civil and domestic, or you would divide that. You'd have the civil judges and then the domestic judges. Is there enough flexibility in the way we're doing things here in Fulton County that when we see an overcrowding issue or we see a problem, and listen, voir dire taking almost a year, I mean, that just, anybody that's familiar with the process, you just lean back and scratch your head and think you're in the twilight zone. But I appreciate the reality and the size of that case. But is there flexibility within the system that when we see these numbers tick up, that we can shift, get those numbers where they need to be, and then rotate back when it comes to civil and domestic cases?
We were very fortunate because our state court, our partners in state court, saw that we asked them, and they volunteered to help us. And for a time period, they took some of our took some of our civil cases, so to allow us to try more criminal cases. And we did that fairly successfully for a period of time to reduce the number of cases that were backlogged due to COVID. So to your point, Chairman, yes, we do have the flexibility to do that. And our civil bar was very, very understanding during this period of time. So I spoke not only with the head of GTLA, but also the head of the defense lawyer, civil defense lawyer organization as well, and talked with them about that we were going to not put a pause on total, civil cases, but that we were going to prioritize criminal cases. And that went over fairly well, and they certainly were understanding about that. We've been able to now kind of get with more throughput, and since the pandemic is, we're behind that, we're able to try a lot more criminal cases. It's, but as I mentioned, the science is really kind of the thing that kind of is still a sticking point, because if I can't get the forensics done, there's nothing I can do with that particular case, or the advocates can't do anything with that. So that's one of our biggest challenges right now. I think to the point I mentioned earlier about people with mental health struggles, I think our competency court is going to also target those people that would ordinarily have maybe sometimes been lost or not been accounted for, to keep them on the forefront so that we can kind of get them through the system and get them the resources that they need, or get the case resolved.
And this is what you're talking about, is an accountability court, much like drug court and others, or?
It's a type of, I wouldn't say it's a type of accountability court, but it's a specialized court that handles just restoration and mental health.
Right, it's a docket. The only way you get on the docket is if there's been a finding that you're not competent for your case to proceed. And we've had a history of struggles.
So it's a medical
Yes, sir.
determination.
Exactly. It is someone from DBHDD who's determined that this individual currently isn't competent, either doesn't understand the charges, can't support his attorney, and so that case is stuck. And it's doubly stuck because Georgia Regional is full, and so we have our own restoration pod at the jail that the sheriff has worked hard to staff and support. But by dedicating some of Judge Ingram's time to those cases, we're at least making sure we're nudging them along. And the moment there is someone who is restored, that's a case that's not stuck anymore, and we jump on that.
And I agree, and I'm very familiar with the program at West Central Georgia and running through. But one quick thing, in full transparency, those cases are a small number, though. And most of them are cases related around violence and things like that, and I appreciate it. But in the overall picture, and talking to the sheriff's office and touring the jail that Chairman Albers and I had the opportunity to do and look into that particular unit, they're extremely important. And these fragile individuals have the same right as everyone else does, but that's not a huge percentage of the overall cases.
No,
Would that be fair?
Correct.
Yeah.
But what we had lacked in the past was a focus on it, and so to Judge Glanville's observation that these cases would get sort of mislaid because there's a delay in being able to move them, and there wasn't a routine channel for handling them, will be more efficient. But in the numbers game, it's a small percentage. I want to add one more fact. I'm sorry, I know we may be running out of our time. In terms of the mismatch between judicial resources and our caseload, and I want to acknowledge resources that Chief Judge Kirk has provided. We have 2 full-time magistrates that handle what we call our non-complex docket. So if you are a non-repeat offender, it's your first entering auto, your first burglary, something like that, we have 2 magistrates who handle all those cases. Those are our busiest, fastest moving dockets. They ought to move quickly, but we had to get outside resources. They're internal to Fulton County, and they're the generosity of the magistrate court, but those are 2 more judges Monday through Friday, who are handling felony criminal cases for the Fulton County bench so that we can stay focused on trying the murders and the rapes and the gang cases, because otherwise they're on our docket, and instead of a 40-position calendar, it's an 80-position calendar, and that slows everything down as well. So it's important that we factor that in.
Thank you, Judge McBurney. This is very helpful. In talking about the mental health population for a moment, right? We've obviously seen an extraordinary increase. And I think if we rewind the clock back to, call it 25 years ago, when the state of Georgia basically had the consent with the feds to close down what used to be the state hospitals in Milledgeville, which I would say that certainly a lot of awful things happened there, and never want to see that happen again. But since then, I think we've found most of those folks have ended up in our largest now mental institution, which are jails and prisons, and/or on the streets. Do you have any idea that you or Judge Glanville on what percentage of the folks that are coming through your courts now are somewhere in that group where we probably be looking to get them into mental assistance first, or somewhere through that process, versus just truly this is a violent criminal?
So the percentages vary because of what is measured as a mental illness. The numbers can be as high as 50-60% of someone saying, well, I have depression. That's not what you mean, but I just want to let you know, if you hear a figure like that, that person may just be using a broader definition. But in terms of folks who are on the verge of, we can't move that case forward because of the mental illness, to Senator Robertson, Chairman Robertson's point, that's a pretty small number. The restoration pot is small at the county jail. Sometimes those people are involved in pretty serious violent offenses. Usually they're quality of life offenses. They have trespassed yet again at a gas station where they're panhandling, and the treatment typically is arrest and take to jail. A step we've taken in a partnership with the city is to develop a diversion center where some of those who are nonviolent offenders can be diverted directly to some form, not quite sure what that will be because there's not been a whole lot of investment in some form of treatment rather than incarceration, so that if we're taking someone to the jail, it's either because this is someone who presents a public security threat, or there's some other reason you need to be incarcerated. Help isn't what you need directly, and that diversion center should be opening in the next couple months.
Wonderful. And who would we follow up with, Your Honor, to learn more about the schedule and where that location will be and the results of the diversion center?
Location is, ironically, the Atlanta City Jail. It's the first floor of ACDC, and I'd be happy to reach out to you. I'm co-chair of the Justice Policy Board, which is the city-county agency that has been behind that. So I'll certainly circle back with your staff.
Perfect. Thank you so much.
Judge McBurney, are we running accountability courts in Fulton County?
We are. In fact, you've got two of the judges sitting in front of you.
Good. Do we run a mental health accountability court?
We do. It's called the Behavioral Health Treatment Court.
Yes,
Dual
sir.
diagnosis, some addiction, also a treatable, as in you don't need to be in a restoration pod, mental health condition. Judge Glanville, Chief Judge Glanville, is our Veterans Court judge. I'm one of the two adult felony drug court judges.
Well, we started one of the first veteran courts in the United States in Columbus, Georgia.
Yes.
I was glad to be a part of that, and New York Times came down and covered us, which is the only positive coverage I've ever had in the New York Times. But I really appreciate that. We had Fort Moore right there in Columbus, and we were having a lot of issues with some of our veterans being forgotten. So I do appreciate that. And on those with behavioral issues that are going through what I typically call the mental health accountability court, are you finding resources where those individuals are able to accomplish their needs outside of the county jail?
Yes, is the answer. We're one of, I think, the only two counties in the state where the accountability court is entirely internal. We don't rely on contractors. So our accountability court staff includes clinicians. So we have trained clinicians for the behavioral health treatment court where they are interacting with the participants, helping them with job readiness, et cetera. So when they graduate, they stand side by side by the veteran or the drug court graduate ready to re-engage, and we see what you'd expect, which is the greatly reduced recidivism rate. But it's an accountability court. Not everyone graduates.
Now,
and
you
there are
pointed,
failures.
you pointed to yourself. I want to be clear. You are not a graduate of the drug court, correct?
Nor is Judge Glanville. But we proudly attend those graduations
Yes.
as we see
I've been to some of them, and they're
tearjerkers.
If I were able to cry, I would. They're very nice. But by hiring the clinicians inside, has there been a comparison of cost of not contracting that type of workout? I can think that the efficiency is much better, but just curious, has there been any cost comparison?
So I do know that the Council of Accountability Court Judges, which oversees all that and seeks to ensure fidelity and uniformity across the state, encouraged DeKalb to follow our model, and that they have found our model to be cost effective. We continue to get grants through CACJ. So I can't give you the math, but I'm certain we could connect you with someone from CACJ who could affirm that if your jurisdiction could afford it, having everyone under one roof leads to greater efficiencies and handoffs between the individuals.
I think so. Now, Judge Glanville, I just got a text from apparently one of your fans watching from home asking if you could be closer to the microphone.
Okay, I can
All
certainly
right,
do
thank
that.
you. And Chairman Payne.
Thank you, Judge, for being here, and thank you for what you do. I truly mean that from our conversation before. The way I'm going through this is I'm looking at, we got, 4 areas. We got the prosecutor in the DA's office, the defense, the public defender, the court with the judges, and then a clerk of court. And so you're saying from those 4, it's basically the biggest holdup is a forensics holdup on all to move cases, or do you see that, or is it just the calendar?
A couple of nuances go into that, Senator. One is the science or the forensics. The other is parties. So you have a DA, you have a public defender, you might have private counsel, but for a number of folks, we have a conflict defender. And we also use the statewide conflict defender. And that is a challenge in the sense that resourcing those particular lawyers, especially our conflict defenders, for multiple defendant cases and getting lawyers to step up. You probably heard our Chief Justice talk about the lawyer oases where you don't have lawyers in smaller counties or jurisdictions. Well, when you have these multiple defendant cases, you've got a challenge of getting lawyers appointed for and to deal with them in a timely manner and make sure all the due process concerns are met. So that is another kind of challenge that we're dealing with. And to that end, our commission has given us some resources to hire or basically engage the services of other lawyers that may be willing to take these kind of cases. But there are multiple issues that go on as to why cases lag, but forensics seems to be one of the biggest ones, because if you get all your science is done, the state makes the best offer that they can do, or they know where the case is going to go or not go, and then the defense has an opportunity to respond and decide, well, I need to take a resolution in this case, or I'm going to go to trial. It would be basically you would be ineffective or not a good advocate if you didn't wait until those particular pieces of the puzzle were in to best advise your client. But the challenge on the other hand is some people stay in jail because they can't make bond. So that's why those kind of cases are very sensitive to us as judges, in the sense that we continue to touch them. Criminals very calendar and participant heavy, in the sense that I, as the trial judge, and my colleagues have to continually kind of rotate and touch those cases in order for them to move.
Thank you.
Judge, I don't know if you've had the opportunity to watch any of the previous hearings, but would you agree if the sheriff's office came in and said that the vast majority of the individuals currently being held in the Fulton County Jail, unable to get out or not choosing to get out, are there for violent and serious crimes?
I think that I don't have the chart with me today, but if you look at the breakdown of people who are in the jail at this point in time, you'll find that a lot of those are, as you said, people charged with violent crimes who are not bond eligible, meaning they've had a bond determination, they're charged with a murder or rape or some other type of crime that the judge has adjudicated, sometimes on multiple occasions, that they don't fit the criteria for a bond at that point in time. You can always, depending upon your circumstances, ask for a bond even if you've been denied one. But yes, to answer your question succinctly, most of the people that I would say that, or the large majority of folks that you have in our jail, have very, very serious offenses that are pending that need to be tried.
And would you also agree that a lot of the cases that are pled, which we know a vast majority of the cases, I'm sure in the high 80s to 90 percentile, are pled out. Those aren't those cases in a lot of you were talking about before. There's a lot of property crime cases, whether we're talking burglary, auto theft, all these other felonies. When we're talking about pleas, the vast majority of those are nonviolent crimes, whether it's somebody's been arrested multiple times or whatever, where, when you're pleading violent cases, murder, things of that nature, I mean, people are, the choices are very, very slim. Therefore, these cases tend to take longer and stick in the system a little longer. Would that not be true?
I agree. The serious violent felonies, if they're going to be a plea, it's on the eve of trial because it's a tough decision that defendant is making. The difference between if I plead and it's 30 years without parole, or I go to trial and it's life, and I mean, they're difficult decisions to make. The counterpoint would be our non-complex docket. No trials, 0 trials in the last 2 years. Because all those cases, entering auto, simple possession of drugs, non-repeat offenders, those plead out. That's how they resolve. We can't plea our way out of murders and rapes. Those are trials. We have X number of judges, X number of trial calendars a month. And so the way you move that faster is more judges and more court. I mean, they don't move faster than that because the way out of jail for that person is a trial.
Yeah.
And to your point, our district attorney, as I tell folks all the time, is the most important kind of entity in the criminal justice process because they get to determine whether or not a case is even brought to begin with. So to that end, she in this case makes the decision as to whether or not the case is going to be made, is going to be pled, or is going to be offered to be involved in plea negotiations. And there are a lot of calculus that goes into whether or not she offers a way to resolve the case. Whether or not the defendant accepts it's another thing, but there are other equities that go into that. How many times have you been arrested or convicted? How many, what type of case it is, and the like. So when we get there, we're bound by what the participants wish to do, what our legislature, you all have set for us in terms of what crimes can be, within the particular range. And that's a kind of a more delicate balance, but, if you can't get some of the things done to begin with for you to assess that case properly, that therein again lies your challenge.
Well, and I appreciate you saying that because, as we said, educating everybody through this process, a lot of times there's been a disproportionate amount of responsibility pushed towards the judiciary, where basically, and not making light of the heavy responsibility y'all carry, you're sitting there waiting to see what comes in front of you. That you don't get to pick and choose who rolls up in there, and the type of case, because you're leaning back into the prosecuting office and you're leaning back into the law enforcement agency that originally made the case, for it to get there. And then the heavy burden in the courtroom is all of the case law that exists in this great country of ours, that you have to hold every bit of it up to that to make sure that this individual gets the due process that they get, no matter what if it was just a poor choice or if it's the darkest, most evil individual to walk the planet. They are all have earned the right to fair due process. So I just want to make that clear that you pretty much are running your court with whatever comes through the door, and I appreciate that. Does any other committee members have any other questions? Does anybody need a ticket taken care of or anything like that while we're here? Okay.
If you shot someone, we can help.
We
We
can
can't help you
help
with a traffic ticket. Sorry about that.
Isn't that the truth? Yeah, I tell them how my wife gets all of hers taken care of is she pays them. So it works out really well.
Good approach.
There you go.
It
There
is.
you go.
Thank you both. I really appreciate y'all coming in, and you brought a different perspective from the court by the fact that someone in your position, Chief Judge and Judge McBurney, who has an incredible reputation, it means a lot to us. So thank y'all very much.
Well,
Thanks for
thank
having
you
us.
for allowing us to come and talk to you, and thank you for your service to the citizens of Georgia.
Thank you, sir.
Okay, all right.
Again, staying on track, Chief Judge Kirk, Fulton County Magistrate Court.
Yes, sir.
And,
And Todd Ashley's going to be joining me.
yes, ma'am.
Brought up the wrong thing. And I did not know if that was going to, I didn't know if that was going to actually come up.
It's your tax dollars at work. It's good equipment, yeah.
Thank you very much, sir. Yeah.
So Judge Kirk, I understand that you're friends with Chairman Payne.
I am.
Well, please do not
Don't
take.
hold it against me.
Don't take it easy on him, and we'll not hold that against you. But
Thank
ma'am, if you could follow as our Superior Court judges did, and let us explain to us your role in the criminal justice system as it exists here in Fulton County, and what impact, if any impact, you feel your court has on the jail overcrowding or the possibility of uncrowding the jail.
All right, thank you. And so I want to make sure that I am able to manipulate this. Yep, apparently I am, so give me just a minute. Good afternoon, Chairmans Albers, Robertson, Strickland, and Payne. It's a pleasure to be here before you today. Thank you for the opportunity to bring our Fulton County team to discuss how particularly the Magistrate Court interacts and impacts with the conversations about the jail. I am Cassandra Kirk, and thanks to Governor Deal and the people of Fulton County, I have the privilege to serve as the Chief Magistrate Judge of Fulton County. With me today is Todd Ashley, soon to be one of our Chief Deputy Judges, but one of our Magistrate Judges in Fulton County. As judges of Magistrate Court, we know that our role is to ensure justice is served, to uphold the rule of law, and protect the rights and liberties of all individuals. As we begin our presentation today, I'd like to acknowledge the vital role of the Magistrate Court in the judicial system and its responsibility in both our criminal and civil matters. I think it's important to note that this court began in 2012. Well, 2012 was when the task force began, and this court was actually created in its current form in 2013 and 2014. Some of you may have been involved in that. The Chief Magistrate Judge position is a position that is chief for 4 years. It is not a position that rotates whomever is elected as chief, and many of you all may have chief magistrates. Actually, you do have chief magistrates in your circuit. We operate very much the same way. Our court is structured possibly a little different than yours. We operate 24 hours a day, 7 days a week, 365 days a year. We have both civil and criminal jurisdiction. Our cases are scheduled by an order of business, which I do prayerfully every year. Right now we are doing that month to month based on the system outages that we are having in Fulton County, a problem that we will soon fix. Our court operates at the North Annex, the South Annex, Central, which is basically downtown, and as well as at the jail. And we have one chief magistrate who has the joy and privilege of appointing 8 full-time, and at this point we have 18 part-time magistrate judges who must both all be approved by the state and superior court. We have 10 ORCA staff who are going to end in 2024, possibly July or September, and then we have 10 permanent staff. I mentioned that we have civil as well as criminal jurisdiction. I explained to people that we are the Judge Judy of courts. If it comes in and it's small claims, that's us. People know us most for our landlord-tenant cases, but we also do garnishment, small claims less than $15,000. On the criminal side, search and arrest warrants, first appearance hearings, warrant applications, preliminary hearings, and we have a misdemeanor mental health court in Fulton as well as a couple of other courts. A misdemeanor mental health court in Fulton, which mirrors some of the other courts across the state. And Judge McBurney has mentioned it. By designation, we provide judicial assistance to our superior court. In looking at our case metrics over time, I think it's important to know that since this court has been stood up, there have been over 634,000 cases filed in our court, and that we have closed over 593,000. These are actually statistics as of December 25th, 2023. You will find, and if you ask, we are a court that continues to look at our KPIs, look at our statistics. We do case metrics weekly, and so these are numbers that we have and we are able to provide to you. If you could share this. Does anyone need one? Okay. Chairman. As we move and look at our actual case numbers, and we've gone back about 5 years, the reason I brought these numbers up and I want to think about them, or I want you all to think about them and talk to you about them, is you can see that in the last 5 years, there have been over 350,000 cases that have been filed in our court. And we have closed, at this point, this includes the beginning of January, because this is from January 30 of 2024, we have closed over 312,000 of those. As impressive as that is, we still have 39,000 cases that we need to get through. It's doable, but let me tell you what that looks like. In 2020, based on those numbers, and if we say there are 250 working days per year, that's 9,887 cases per judge, and that's for the 5 full-time magistrates that sit in magistrate court. Moving to 2021, obviously our case numbers increased, and so that breaks down to about 12,357 cases per judge per year. Moving to 2023, just to short circuit a bit, that's 15,581 cases per judge per year. So that's about 62 cases a day for those 5 judges that are working in magistrate court. The question really here has been, what does this look like? What is the magistrate court impact? So only follow the blue. That's all you need to know, right? So the first place that magistrate court will impact this system, the jail system, is with the warrants. And we do an electronic warrant system, which allows those 15 jurisdictions, as well as the colleges and universities, to come and have contact with the judge 24 hours a day, 7 days a week, 365 days a year. Following the warrant, we move to first appearance hearings. Our first appearance hearings are not just first appearance.
Judge,
yes, sir.
excuse me real quick. You said the warrant system is electronic?
We have an electronic warrant system through Palatine, the Anywhere warrants.
So they take their oath electronically?
Yes, sir. It's like FaceTime.
Oh, okay. Okay, thank you.
We're moving on to first appearance, and so first appearance is not just first appearance, and we only do felony first appearance. The Solicitor General actually accuses his cases, and they move to a C calendar, which is a different calendar than the first appearance calendar. At first appearance, part of the magistrate judge duty is also to figure out who else is in the jail and handle those cases where warrants have come in, people have bench warrants, so it's just to touch everybody that's in the jail. The other piece is we also do vehicular homicides misdemeanors, and then for any of those individuals where there are extraditions pending, those all come from 11 to 11:30 so that we can start felony first appearance at 11:30. Moving on, if you are coming from the C calendar, sometimes from first appearance, you have an opportunity to be at our misdemeanor mental health court, which we will talk about a little bit later, or if you are coming straight from if you're coming from a citizen, the copy of charges calendar is basically a citation calendar. If we are looking at those cases that are unaccused and unindicted, those preliminary hearings, and Judge McBurney mentioned this, those are a magistrate judge that sits there on behalf of Superior Court, and then there are also bond hearings in our non-complex division. As we're looking at the plea and arraignment, it is only in the non-complex division that the magistrate court judges support Superior Court there, and Judge McBurney and Judge Glanville have spoken about that. Now, We talked about the beginning of this system being the criminal arrest
Your
process
Honor,
by
if you
warrant.
give me a quick second, we have some questions. You're on 6 or 7?
7.
7.
Thank you. I thought before you get into the criminal stuff, I had a couple questions about your structure. You say you have 8 full-time magistrate court judges, 18 part-time. Who decides how many judges you have? Is that a county decision?
So it's a resolution by the county, and we can have up to 22 part-time. And we actually, by a vote of the state and Superior Court, we have this year, by funding of our county, we actually have an ability to increase the full-time judges to 10.
Do you think you need more magistrate court judges if the county was able to give them to you?
So there's only so many places they can sit, which is the problem. Right now, we have 9 courtrooms, and so that is also a limit.
And you mentioned sitting by designation for Superior Court. Are particular cases that our Superior Court in Fulton County has you sit on in particular?
So it would be those individuals at the non-complex division. So those where it says plea and arraignment non-complex, those would be the ones that Judge McBurney spoke of.
And what about any civil matters, for example? Do you hear TPOs or anything like that by designation?
We don't.
Okay, thank you.
And real quick, on the civil side, the max, if I'm correct, is 15,000, correct?
It is currently 15,000.
I've been
Yeah.
lobbied for the last 4 years to increase that number.
Right.
And I would greatly appreciate your opinion on that if you're comfortable giving it, for the reason being, if that number is raised, and I've got 2 very stoic faces, Superior Court judges back there in the back, wouldn't that, if we put it somewhere, wouldn't that alleviate some of that pressure in Superior Court on the civil side if we tick that number up a little?
So it's my understanding, and I think our council has a position and has taken a position on that, or maybe our council is just waiting. I don't want to speak out of turn in front of my council,
That's the reason I
but,
asked for just your opinion on it. It's, yes.
and you know, as a judge, I don't really have an opinion, right? I've got the law and I've got, anyway. So what I will tell you though is
Ma'am,
having looked
I have
at.
a lot of friends that are judges, and you'll all have opinions, yes.
Having looked at access to justice and just kind of the way that works, and having actually studied some of that, I believe that increasing that limit gives parties an opportunity to come to court for those cases that may be up to 25,000. I would say more than that. So there are a lot of jurisdictions, right? So we have to think there are a lot of jurisdictions that do not have lawyers that serve as magistrate judges, and so that is also a
Yes, ma'am.
consideration.
Thank you, Chairman Albers.
Well, I was gonna ask a question, but did you just say you have magistrate judges that are not lawyers?
No, not in Fulton County. So not in Fulton
Okay.
County, but there are of the 159 circuits. So as a matter of fact, in training for magistrate judges, there is a course that is non-attorney civil, non-attorney criminal, and it is a 40-hour course for each of those.
Yeah, I believe we were working on that a couple of years ago, if my memory serves, potentially.
Thank you.
Changing
And
that.
Judge Ashley mentions it's based on population.
It's based on population. And
Thank you.
yeah, it's based on population. I forget what the number is. But as you heard the Chief Justice say the other day, the issue is finding people with a bar license some places. So it's by necessity.
I
in a lot of
understand.
situations.
My other questions, we were mentioning courtroom space. Is it absolutely incumbent upon you to meet right here, or could you utilize other courtrooms in other parts of, we'll say, Fulton County, either North or South County?
Well, and so we do use the North Annex as well as the South Annex. And so in those courtrooms, we hold small claims hearings, and then we also hold environmental and copy of charges. So we do spread ourselves out.
So if there's more capacity, though, in those courts, which might be easier just based on their location, would that help alleviate the opportunity of increasing your judgeships to hear more cases?
It would allow us to schedule more cases and possibly increase our scheduling. So right now, we're constrained by the number of judges, we're constrained by the number of courtrooms, but we're also constrained by the number of bodies we can place there. And placing a full-time versus placing a part-time is just a monetary issue.
Yeah, and I think this all gets back to a little bit what Chairman Robertson was saying about the 15,000, which has not been adjusted for inflation in I don't know how many
Yes.
years or decades now, that perhaps better use of people who are more, I wouldn't say more knowledgeable, but maybe more focused in one area versus another area would make sense. So we'll work on that offline. I know you don't have a necessary opinion. I did want to take a moment, though, to recognize Judge Ashley, who I've known for a very long time as a dear friend, and he has really helped put an intense focus out in the area that I represent in North Fulton County, from his days in the prosecution to what he's doing today, and just a tremendous public servant, so thank you.
Am I still your favorite constituent?
Number one.
Now, his other favorite, his other favorite constituent was here yesterday. If you- yeah.
Fair enough.
Judge, are any of the hearings y'all are doing, are any of them virtual?
So our status hearings is virtual, and because we are really the people's court, it's important for us to be able to judge credibility. It's important for us to be able to see people, and it's my preference that we have hearings in person. So those cases that we have, for instance, garnishment is a mainly attorney case, and that's something that can be done online. Motions, that's something that can be done in hybrid. The landlord-tenant judgment on the pleadings calendar, that's something that we do online, again, mainly attorney cases. But for those cases where citizens are walking in the door and saying, Judge, what is the ruling? It is my preference that those cases be held in person.
Do you see an opportunity moving forward at some point where we can expand a little bit of the virtual side to lessen the bricks and mortar requirement in the justice system? And I see my guy with a law degree who wants to count mileage on his invoice to my left. But I know when I asked you about the oath a while ago, I mean, I've stood in the rain in judges' front yards with my right hand held up getting a warrant. And so I was a little concerned about somebody taking an oath virtually.
So I will tell you that during COVID, one of the things we realized is our county IT department was amazing, just getting us up and running on the virtual system. But the problem is what we realized, a lot of people that we served didn't have the bandwidth on their phones, didn't have a phone that had the capability. And so for the population that we serve in the magistrate court, it would be more difficult to have an all hybrid calendar.
And I respect that and I appreciate it. And I've run into this, and again, to get myself in trouble, I know in the building and design of judicial centers and other things, there's always been where every judge wants their own courtroom. Every judge wants their own hearing room and those types of situations. And that's just a heavy cost to the taxpayer, money that could be used in other places. And I know y'all actually doing the 365, 24/7 is incredible. And I know y'all have space in the county jail where you can expedite cases through there. I think what the two Superior Court judges spoke about, y'all leaning in and helping them offset those cases that are 100% pled. And, you know, sitting here right now, I think that's a model that should be used around the state with the numbers that you're showing us to alleviate some of the overcrowding in the Superior Court so that the cases in the jail, and I want to focus on that, the serious cases in the jail could be put in front of a black robe a lot sooner than having to stand in line behind cases that are going to be pled eventually anyway, based on the numbers. But I would like to see an opportunity to look at virtual to where it can be, you know.
Yes, sir. I think there are places where it's appropriate, so I will
Yes,
give
ma'am.
you that. Yes, sir.
Thank you, ma'am.
Absolutely. And then I do want to be very clear that the numbers I posted, the 634,000, that's mainly our civil and our magistrate cases. So that's not including what we do for Superior Court. As we look at warrants, because I think it's important to know where these warrants are coming from and who is making it to the jail based on these arrests. As it relates to felony crimes, almost every one of those is going to the jail. With respect to misdemeanors, some of those individuals are going to be able to have a bond set. Actually, all misdemeanors are entitled to have a bond set. So they will have a bond set. Whether they can meet that bond or not is going to be kind of up to them and their family. And then the number of search warrants that we also do on the electronic warrants. So I just wanted to give you all those numbers. And back to our misdemeanors, those misdemeanor defendants accused that are charged with family violence will also be sitting in the jail until they actually get to see a judge. Okay. And when I did a breakdown of our felony warrants, I wanted to note that the number of aggravated assaults, armed robberies, those cases that people are most concerned about, those are not low numbers. And so, yeah, I just wanted to give you all an idea of what that looks like. Now, following the issuance of the arrest warrants, the accused is brought before a judge for first appearance, and the judges are provided information from pretrial services. We get to hear arguments from both the state as well as the defense, and then we make a determination about bail. We make a determination, notify them of their charges, and then tell the accused of the next court date. Over the last 5 years, actually starting since August of 2019, I have been on a task force that has been looking at advancing pretrial policy initiatives. It was started by, I believe, Yolanda Lewis, who is the court administrator back many, many years ago. And that is actually coming to a head now in 2024. But one of the most prominent accomplishments of that 5-year study is the development of the public safety assessment, which is a predictive tool that talks about how it is it talks about the success of an accused and provides a risk factor for the judges. And so that's another piece of information, as well as the release conditions matrix. So
Is this around the particular individual based on criminal history?
It is.
Socioeconomic, education, all of this?
It is.
Okay, and how early are we into this?
So this is actually given to the judges at first appearance. This is the pretrial services team that is led by Superior Court. I want to say it's actually David Summerlin's team, and David is here, but it is the pretrial services team that provides this information to our judges.
Is there any kind of tool used to come up with this assessment? Where we talk about, and I'll date myself, a Scantron type assessment to where the individual answers an array of questions, we feed them into the system and come out with something?
That is absolutely the way it works, and it is a validated instrument, validated specifically for Fulton County. Like I said, we've been doing this for about 3 years, so it's not actually a Scantron, but it is information being fed into based on
Chairman Strickland.
Right.
Chairman Strickland said when I was there, just tap it into a rock.
Right.
Was how I was thinking.
Absolutely.
Thank you.
And so in terms of the number of first appearances that have been held in 2023, the number of cases presented, that number 27,000 is the number of cases, not the number of individuals, but the number of individual cases that have come before the court. And then I also have the numbers just as we talk about January 2024. One of the issues I know, and Chairman Albers had concern with over the years when this was first passed, and we have been, at that time, 2021, I believe, we actually made, one of our judges, Judge Drake, actually made a checklist for our judges to figure out whether or not a UJR was appropriate, and we used it back then and continue to use it. But I wanted to share with you all the information that is provided, how many of those actual felonies receive UJR. And you will notice that there are two indications. There's a UJR pretrial services. That means that that individual is actually being followed by pretrial services. UJR jail means that that individual poses such a low risk that they are simply released from the jail. Now,
Chairman, just one
Yes, sir.
moment.
Finish your thought.
What I was going to say is that at one point, pretrial services only worked up until, or only followed the individual, monitored the individual for 4 months. That has been expanded, and so now pretrial services actually monitors those individuals under UJR PTS through disposition.
And thank you, Your Honor. You and I have worked together on these
Yes.
issues for many years now. This is very helpful. One of the things that I don't know if we have the answer to today, but it might be a good output from this, because this is all started because of the issues and the loss of life and the overcrowding in Fulton County Jail, is in the breakdown of the current folks that are currently being incarcerated there. Where are they in the process? Are they in your court? Are they in your courts? Where are they? I think that would be helpful for us to look at as we dig a little deeper, Mr. Chairman.
I agree. And also, I'm curious, a lot of these tracking and following that's going through the court, are we using any electronic devices to follow these individuals? Are they physically coming in and reporting, or are we just trusting they're not out violating?
So I'm going to defer to David, but I know what I know. I'm going to defer to David Summerlin. I do know that pretrial actually makes physical contact, and on our misdemeanor mental health court, we actually have a tracking device that is on their phone. So it's not a tracking device. It's a it's a collateral support that's actually on their phone.
It's an app?
It is an app.
Yes, ma'am.
Yeah.
Okay.
And this was just our UJR checklist that I know.
Okay. Chairman Brass.
Thank
Yes,
you,
sir.
Mr. Chairman. Thank you, Your Honor, for being here. I want to go back to these numbers on cases by the numbers
Okay.
slide.
Yes, sir.
And think about how to phrase this, but is there any direct correlation on these numbers and like how many cases we're seeing, and then and any kind of backlog? Is there, I mean, and I guess, let me kind of help get through my thought process here, if you'll bear with me.
Absolutely.
So in 2019, there were 80,000 plus cases,
Right.
which is about 219 a day that were filed.
Okay.
Okay, and I mean,
I'm not a math major, so
I know, I
won't-
just
won't
divided it by
dispute
365. So,
He's a
and
golfer.
sorry.
He's a golfer.
And then 2020 pandemic, we dropped down to 49,000.
Right.
And then 21, we started creeping back up, 61,000, then 76,000, then almost 78,000. All right, so the trend there, we went from 219 a day, pandemic hits, we did 135 a day, then 169 a day, then 210 a day, then 213 a day, and now in 2024, there's 114 a day.
Okay.
So cases filed are back to below the pandemic year. Is there any kind of correlation there on what you're seeing on cases filed and people in jail? Or, I mean, I'm just trying to understand why this trend, I understand the 2020 dip,
Right.
but help me understand the 2024 dip.
So these numbers are mainly civil cases as well as so this is only magistrate court cases. So this is
Right.
not going to include any of those jail cases.
Okay.
But I will tell you that as we came back in 2020, 2021, we didn't really fully come back into court with the number of people that are able to sit. I don't know if you all recall that as we came out of 2020, like there were tags on seats. You can stand here, you can sit here, you can have 6 people in a room, you can have 3 people in a room. And so that affects the number of people that you can actually deal with and manage. In terms of case filings, I know that the majority of these filings in 2020 were really from our landlords. And so they continued to file even though there were all of these moratorium and things that suggested they should not. So I'm not sure if I'm answering your question.
For Senator Brass, that the warmer it gets outside, the more crime we see. And it's pretty cool right now in January and February.
It's seasonal.
It's seasonal.
No, it's,
Very accurate.
but it is, when high school lets out, crime rates go up,
Yes.
college
Okay.
quarter
That was a true
semesters and
statement.
temperature. yeah.
All right, that makes sense. And that helped form my question. Also, your printer's almost out of ink.
So actually, it's a printer that's dying, and so welcome to Fulton County. I got plenty of ink, it's just my printer itself is dying.
I got you.
So, yeah.
So Judge, is the Fulton County providing you enough funding for printer ink? Is that fair
Am
to
I
say?
ignoring this question because we're on air? I think I am.
Yes,
So,
you are.
The last thing I want to talk to you all about is our misdemeanor mental health court. And this has been something that has been stood up since 2018, but this is a partnership. It is a partnership with our Solicitor General, our Public Defender, our Behavioral Health Team, our state court, as well as our magistrate court. The parties that really serve here are our, as you can see, this is one of our graduation pictures. You've kind of got everybody. We've got a list of all the graduations we've had, but there are 2 opportunities for people to join the misdemeanor mental health court. You can either join from the jail, which is a jail calendar that we held every Thursday, or you can join from plea and arraignment. So you've gone to state court and someone says, oh, you have mental health concerns, do you want to come to court? And this is a voluntary court, and so those individuals come and join us. As I look at our numbers, there were 442 candidates reviewed, and so as people are coming into the jail, our first touch on them is based on the criminal mental health screening. So that first screen they get determines how it is they are lifted up to our team. Our coordinator, Georgie Corley, is basically looking at those sheets that come from the jail every morning at 6 o'clock to determine if there are people that we need to move to our Thursday calendar or that she needs to check with the state to make to our Thursday calendar. But of all of those 442 people that came as candidates for us in 2023, 336 of those were rejected, and that can be because of their criminal history, or it can be because of the family violence nature, if it's a husband-wife versus a child-parent. And so that makes a determination. We are asking our Solicitor General how it is we can open up the number of people that are actually accepted into this program, because as you can see, we have a 72% graduation rate. Since 2018, we have had 71 graduates. And so and that's where we have our app. It is a Sprocket app and it is a gamified app. You are correct. So That is the end of our presentation. I just wanted to give you all an idea of what Magistrate Court does, how it is we work with all of our judicial partners, all of our justice partners. And Judge Ashley, you didn't have much. Did you wish to say anything?
I hope my testimony was helpful.
Well, I think once we realized that you were Chairman Albert's favorite constituent, you had biased yourself beyond testimony. But
I should remain
but
silent.
Judge, you brought up something. The ORCA is about to go away.
Yes.
Okay, and you have 10 judges assigned to that?
So
Or
not
10
ORCA's 10 staff.
10 staff?
Yes, sir.
Okay, so when ORCA goes away, do those staff go away?
They do.
Okay. And ORCA has primarily focused on civil, is that correct?
So it's been criminal and civil, and so we use them for whatever calendars are running.
Okay, thank you, I appreciate that.
Thank you. Thank you all for having us today.
Thanks, y'all.
Mr. Chairman, I just wanted to let the committee and everyone know, since we started, we announced this committee back in October, the numbers have come down significantly from who is currently incarcerated in the population that we actually physically have custody of. And it's now down to a total population of 2,857, which is significantly, I think it's 800 or 900 less than it was at its peak. And including in the main jail, which is down now to 1,879. And why that's so important is for the renovations that are desperately needed at that jail that can now take floors and blocks off at a time to do that. And as we mentioned earlier, as the chairman so eloquently put it, out of the four legs of that stool, everybody working together has seen that. And I always remind everybody who's here today, but also those in the media might listen, that we have to report the good news, right? We can't always put the most outrageous thing that we see and make that the headline that continues to go on. So let's take a moment and be grateful for the progress that's also been made here. So thank you all.
Okay, and for us to stay on track before our landlords ask us to leave, I would ask Madam Clerk Alexander if she would come up with whoever she needs.
I'm all alone.
Well, I want to tell you, I would love to believe you are, but I notice you have Sky standing in your shadow up here and always advocating for you. And if I don't give you credit for anything else, you're a very smart lady to team up with somebody as smart and as intelligent as she is. And whatever senator allowed her to escape his office should be ashamed of himself. He should be.
He should be. She's the best.
She is, but Madam Clerk, I think what we really need today is an understanding of how the cases get to you, how the dockets are managed and created and pushed over to the Superior Court, and how you feel that things that you do help alleviate the overcrowding issues, and what possible solutions you feel are out there that we could talk about to help you get that number even further down.
Okay, so thank you guys for having me. I don't have a prepared presentation. Here to just inform you of what we do in the clerk's office. And you started off earlier by saying, you know, I talk to my friends and they're like, what do you do? Nobody knows what we do, right? So just briefly, you have the judges, you have the DA, you have the sheriff, and then you have the clerk. I am the heartbeat of the justice system. Without an efficient operation in our office, it could be shut down, right? So we manage all of the civil, criminal, real estate records that come through the county, which you guys know is the largest county in the state. We're here today to talk about the Fulton County Jail and the criminal cases, so I'll make sure I keep my conversations geared toward that. Once the arrest is made, Judge Kirk talked about the judges being in first appearance. My clerks are in first appearance. The warrants come into our office. We create the cases. The jail tells us how many people were arrested that day. We create the calendar for her judges to say, this is what you're going to do today. So the movement starts there from arrest to disposition. Once the person is arrested and there's a case, the information is with the prosecutor, right? I'm only doing felony cases. There's a different clerk that handles the misdemeanors. all of the cases are in the district attorney's office, and so from that point, after first appearance, the judges manage the preliminary hearings and all of the hearings that happen before indictment, and until the cases are indicted, that's the next phase, right? Once the prosecutor decides on what cases she wants to indict, we manage the indictment. The indictments go to the grand jury. Once they leave the grand jury, they're handed over to a judge. The judge hands the indictments over to a clerk, and we process those cases. There's a wheel. There's a wheel that randomly assigns the cases to the judges. So, as the judges talked about earlier,
Excuse me, can you please say, what do you mean by when you say there's a will?
there's a random assignment. So the clerks don't pick and choose to say, I'm gonna give Judge McBurney this case, I'm gonna give Judge Adams this case. We don't do that. The system randomly assigns the judges cases.
And do you also assign civil cases?
We do.
Right.
So the system, two
Right.
separate systems, they randomly assign the cases to all the judges.
So there's a will that handles the civil side and a will that handles the criminal side.
So there are
And-
several wills,
Right,
yes.
because I'm saying there are domestic cases that are
Family
assigned,
cases.
and are those assigned by your office also?
Right, so there's a family will that has the 4 judges on it, so it'll go randomly to those judges. And then there's a civil will that has the other 16 judges on it, and they'll randomly assign it to those 16 judges for civil cases. So that's 2 separate wills.
The criminal will has the 16 judges on it also, right?
So the criminal will, it's a little different, right? So let's keep civil over here, 2 wills, a family will and a civil will. Now let's go to criminal.
Right.
There's a murder will. There's a general complex will that just lumps all those cases. There's a sex crime will, right? Because as the judges talked about, in Fulton, we have so many different types of cases that are just, you can't lump them together, right? So the bench decided that we would take the most egregious charges and have separate wills for them.
And-
So
and
that
no-
it won't be, go ahead.
And I do understand that. I guess the point I'm trying to get at is these 16 judges we're talking about, they're on multiple wills. So you may have a will that spins and throws a murder case over to Judge McBurney, while at the same time, a civil will is turning and throws a civil case
Absolutely.
over to Judge McBurney. And then some other unique will within these separate categories that tosses an entirely different case over that way. But the only will that has the limited number of cases is the will with the 4 judges on it, and they're just family, correct? So that Judge McBurney could have a cornucopia of cases, but he will not have a family case.
That's absolutely correct.
Okay, thank
Judge
you.
McBurney, with your example, Judge McBurney, based on the wills, could get 7 different cases on one day at that time. Or he could get 20. It just depends on how many indictments come through, how many civil cases are filed, and how the wheel rotates. On the civil wheel, there is 1 for 1. So all the 16 judges will get 1 case before the next judge gets 2. So it's random. It's not, you can't judge, you can't pick the judge because the system does it. But on the criminal side, there are different wheels. There's a murder wheel. There's a multiple defendant murder wheel with defendants, because we have so many different types of cases. And so then there's the general wheel where they get cases assigned there. So once we do that, we have the indictment, we code it, whatever type of case it is, and then those cases are assigned randomly to the judges, and that's when it becomes their case, not pre-indictment, not when the person is arrested. They have no idea what's coming to them until the system assigns those cases
So
to
to
them.
continue throwing Judge McBurney under the bus,
Let's
so
continue.
would Judge McBurney get 2 dockets? Would he get a criminal docket and a civil docket?
He does.
That would cover, I think in his words, was a month. He said each month is there a fresh docket that comes out?
Oh, no, there's
The
every day.
calendar, excuse me.
Oh,
Okay.
So every day, the civil cases are being filed as we speak, right?
Right.
So that's coming in. The DA has a double grand jury going, so we get indictments 4 times a week before the system outage. We get indictments 4 times a week, so they get cases every day.
So every morning when a judge gets into his or her office, will they find a new calendar for that day?
So it's not a calendar. right?
Okay.
So what happens is the judges, and I want to just clarify something that Judge Glanville said. The clerk is not responsible for creating the calendars for the judges.
Okay.
The judges decide.
That
So
was my
that's-
concern, because I know the judges are responsible for scheduling while working with the public defender's office, the district attorney's office, and private attorneys, based on motions, based on, like they were talking about, the science available and all of this stuff. And then I assume the judge has somebody on staff that actually
in the
puts the
Superior
calendar
Court,
together.
right. In the
Yeah.
Superior Court, they have their team.
Yes, ma'am.
Their litigation managers, staff attorneys, and their team that creates their calendar. The clerk's responsibility is to give them the cases, and then they manage whether they want to do criminal today, whether they want to do civil today, it's up to the judge.
So once you send them their cases, then your next engagement is once the case is adjudicated and they send you back the disposition of that particular case, and then your staff enters that disposition into the system. Is that accurate?
That is accurate.
Okay, so once it goes out, so the case is made, the individual is carried to the jail, and then who gets you the information that the individual is inside the jail?
When they're arrested?
Yes, ma'am.
So we get that every morning from the jail,
From the sheriff's office?
from the sheriff's office.
Okay, if the individual should post bond and get out, then that information is also sent to you, and then that is placed in your system, showing that the individual, even though the case is pending, they are out of the county jail.
Good point. So we talk in two different tracks, because mostly the people that get out are misdemeanors, so they're really not in my.
Let's say
Right.
felonies.
So felony,
These are
if they
felonies.
bond out, most of the time, you don't really bond out of a felony case before court. You get out at the first appearance, but if they get out before first appearance, it goes into the district attorney's queue for prosecution. It doesn't really, I have to create the case if they have court, but if
Right.
they bond out before then, we're aware of it, but that information goes to the prosecutor.
Right, and I want to be clear, looking at the sheriff's numbers, the vast majority of nonviolent felons do bond out.
At the
And-
first court hearing.
Yes, ma'am. So when you say court, you're not talking about Judge
I'm not talking
McBurney's
about
court.
Judge
I
McBurney's
just want to be
court.
clear
I'm
to,
talking about Judge Kirk's court.
right. So once they bond out there in Judge Kirk's court,
Right.
does her court send you the information that they have bonded out? Do they don't go in your system at all?
I'm there in court, so I know.
Okay.
They can't bond out. Think about it. I told you in the beginning, I am the heartbeat.
Yes, ma'am.
So, which means they can't get out without me doing the paperwork. So if
Oh,
they
no.
bond out,
No,
I have the
I
bond.
understand all
right.
that. What
So
I'm
it's
trying to
there.
say is if I go into your system, can I track the individuals in jail on Monday? And then on Tuesday, they made bond. I'm looking at your system. And then they made bond. Now, that doesn't prevent you from continuing, because you still have to assign that case to the applicable court based on how it pops up on the wheel.
It doesn't until the DA indicts. So
Okay.
it'll go in a queue for the DA. So it's an unindicted, pre-indicted case, right?
Right.
And so they bond out, it goes in a different queue for the DA to indict. It's the judges would, if someone bonded out after their first appearance, before it turns into a case that I've assigned to them, they will have no knowledge of that person.
Okay. So you don't assign the case until the indictment.
That's it. Case assignment is done once the DA decides to indict.
All right, and then once they're indicted, it goes into the process,
The wheel.
and they're spun out, and you don't touch it again until adjudication, whether that's dismissal, acquittal, or conviction and
I don't
sentencing.
touch the case again, but when the motions are
I'm
filed,
talking in your system.
everything is tracked in my system. So when they have court hearings, the calendars, we mail the notices telling the people to come to court when they schedule the hearings. They only do their calendar. The clerk does everything else. So we mail the notices, everything that's filed comes through the office, is on the docket based on the information we receive. So the orders, the motions, the entry of appearances for the cases, everything comes through us. And that's how the judges manage their docket based on the information that we give.
And in that case, post-indictment, once you've sent the case, as the judge receives the case and he or she and their staff put the case together and they schedule the case, then they report back the scheduling to you, and then you generate the notifications beyond the attorney's responsibility to making sure that the defendants, any witnesses, and all this are notified, subpoenaed, if you will?
Oh, okay, good question. So we notify the parties, the attorneys, the defendant. We take the calendar, we make sure that it goes to the legal organ so people have that type of notification. It's the prosecutors and the attorney's responsibility for doing the subpoenas. I mean, we sign them, but they have to have the subpoena served. We don't notify witnesses.
Right. You just notify the parties via the attorneys. It's
Yes.
up to the DA's office and whoever's representing the defendant to make sure witnesses and others are there?
That's correct.
Okay.
Thank you, Mr. Chairman. Madam Clerk, you were very gracious to spend time with me and give me a little bit of a background on what you did prior to becoming full-time into the clerk's position. And I'd like you just to spend a few minutes, if you would, to educate the entire committee on the work you were brought in to do, what you helped bring before even assuming your new role.
So thank you for that question. I've been born and bred, Fulton County is my home. I've been in and out of the clerk's office for 20 plus years. In 2018, I stepped away to start my own consulting company. So I went around the country to help clerks become more efficient, paperless, and to just talk to them about the system. So my experience on the justice system is not just Fulton County. And so I was approached by the Metro Atlanta Chamber about an issue that Georgia was having with GBI and the transmission of dispositions, right? So there were the clerk has these dispositions and they're not entered.
Are we talking about GCIC?
GCIC.
Okay, thank you.
Yes, sir. And so the Metro Atlanta Chamber went into contract with my consulting company to start a project to figure out, like, what are the issues going on in Fulton. It was the pilot. So we researched, with my experience, I knew that, you know, the numbers show that the GBI we have 5 million open charges in Georgia. 1.5 of those are Fulton County. And so what is going on? The dispositions are in the system. If you go to the clerk's office, there are dispositions there, but they're not in GCIC. And so the chamber, we knew that 1.5
Madam
million
Clerk, real
charges.
quick, can we explain the problem with that? That the fact that the dispositions are in the clerk's office, but they're not in GCIC? Could you please briefly explain what kind of problems those cause when that happens?
So what happens is we have an electronic transmission from our case management system to GCIC. If there's anything off, it rejects. And no one was really managing the rejections.
And what's the danger of that?
There's twofold. The
Right.
danger on the side of the defendant that got a case that was dismissed, a case that never should have come, and they have an open charge on their disposition, it could cause them not to get housing, it could cause them not to get a job, it could have a negative impact on their life because
What if
the
they get,
system
what if they
wasn't
get pulled
updated.
over for a traffic violation and their name is run through GCIC and there's an open charge or there's a lack of a disposition? Is there anything that could happen there?
Not on that end. It's
Right.
just the judgment piece, only if they had an open warrant. If they got
Right.
pulled over, unless there was an open warrant that wasn't closed properly, that would cause them harm.
Right.
The harm in not being able to get a job and people judging them because of an open case that should have been
A
closed on
criminal
that side.
background check by any business would come up and show no adjudication of that particular case.
Right, and
Show
people
it-
that don't understand that, if you are an employer and you say, oh, that this person has an open ag assault, I'm not gonna look at them, and it should have been closed, it hurts on that end.
And you said how many of these types of cases or did you discover initially in
So
Georgia?
there was Fulton's issue was 1.5 million open charges,
Right.
right? And so to go into, should they be open, because some are still open, should they be closed, or that was the research, but we just did a pilot of a certain amount of them. But the other side of that, for the judges, if I'm in front of you and you're running, you know, and the criminal history says that, you know, Shay Alexander has X amount of convictions, and if it's not there showing a conviction, the judge can only sentence based on what's in there. So it's a twofold process with these. It's a twofold process with these errors for GCIC.
Here's the landlord. Yeah, the landlord's here.
The landlord's here. Are we being put out?
Be on your best behavior.
So I just want to point out, he did not come in here and stop me.
Oh, okay.
So, a little bit, yes, it is.
So the errors, let me just
Right.
fast forward to the errors. The research found that there were, it's a system problem. It's not one agency. It's not just the clerk, it's not just the judges, it's not just the sheriff. We found that there were duplicates where the person had been fingerprinted more than once, which is a problem because when you close the case, you're only closing the one case, so the duplicate case is never closed out. We found that we were, as Judge McBurney talked about earlier, there is a failure to appear warrant process that was antiquated. That we were fingerprinting people and we were calling it a FTA, a failure to appear, but then it went to the GCIC as an FTA, but the judges never had a case calling FTA. So those hundreds of thousands of cases were just pending. So there were, FTAs, there were bench warrants that were just there. There are duplicate cases. There were arrests in College Park.
Now, when you say there were bench warrants that were just there, were these bench warrants that had already been taken care of? Or were these bench warrants that had not been executed?
So a bench warrant from a fugitive from justice, if you had an issue in South Carolina and we arrested you here in Fulton, well, your issue is with South Carolina.
So you'd have a hold on you and you'd be held here on a warrant from South Carolina.
Right, and you should go back to South Carolina to get it dealt with. But we had so many lingering charges where we fingerprinted those folks for charges in other jurisdictions that we should have never fingerprinted them on for charge. We should have fingerprinted them on for identification purposes.
But nobody was being held because of that, correct?
They weren't being held, they were going away, but it still
Right.
showed up that we had missing dispositions that technically weren't missing dispositions because there would never be a disposition on a case that happened in South Carolina, if that makes sense.
It does.
So those issues, the fugitive from justice, the warrants, the duplicate charges, we have 15 municipalities in Fulton. If College Park fingerprinted and then brought them to the Fulton County Jail and then we fingerprinted them again, problematic. So it was those type of issues that we found. We went to every agency. What I can say now about, coming back to Fulton County right now, I've never seen this type of collaboration with the justice partners. I mean, the DA, the sheriff, the judges, the clerk. I mean, we collaborate, we talk. And so right now there's systems in place. I created the GCIC unit so that we could real time help the repeat offenders and update these GCICs. So I just want to give a big thanks to the Metro Atlanta Chamber from a business side of it, something that was able to we were able to accomplish it with the funds coming from the outside that I don't think we were been able to accomplish
So how
from
was
the government.
how was the problem solved? Was it understanding policy through collaboration, where you're talking about the one agency, which I assume would be the primary agency, fingerprints the individual? Did something come up where they would say, okay, we'll bring them to the county jail and then the county jail will fingerprint them?
Good question. We stopped the bleeding by training. People didn't have any standard operating procedures. No one really knew. You got trained by the person next to you. So we did specific training for the clerk's office, the DA's office, and the sheriff's office. All of the elected officials committed to moving forward with the new process. If College Park fingerprints now and they bring them to Fulton County, so we didn't reach outside to the agencies telling them what they should do. We just made recommendations. So if College Park did fingerprint, when they came to the jail, they knew not to fingerprint.
Okay.
And now with my unit in place, if something happens and they did, it's real time. Hey, you just fingerprinted Johnny twice.
Do you have TAC officers within your unit
Yes.
that audit according to the GBI standards?
Oh, absolutely.
Okay, and all these others that go into GCIC that collaborate with you, they have those same ones so
They
that
have
everything
to.
is consistent, right?
Yes,
Yeah.
we have consistent policies and procedures now. Each office has their ORI number. We're audited, and then there's a system in place for if someone sees an error, we're correcting it real time, making the communication with GBI and the different
So
agencies.
is all of this done off this incredible manual that I've heard about?
Yes.
That your friend at the chamber promotes as the second coming?
And they promoted, they should get all of the credit. I mean, it's amazing. We have single-handedly with this process put everything together and identified probably 95% of the issues. And working with GBI, we have a little more work to do with the CDX board. We're working with the CDX board, but we're on the right track.
Any idea where we're at from the 1.5 million?
So that's a big task. We cleared about, and it doesn't sound like a lot, but think about it this way. We probably cleared 40,000, 60,000 of the high chart. Like we just did the most egregious charges. But the win is that we're not accumulating more. So we're gonna have to, bite small pieces of the elephant to get everything cleaned up. But if you think about this happened over years and years, decades and decades, if we're not adding to it, it's better now that we'll be able to attack the backlog.
I agree 100%. And is this a solution that can be used in every clerk's office throughout the state of Georgia? And is it being adopted or reviewed?
So we have the CDX board has created some standards for the clerks across the state, and yes, we are looking at putting those requirements in place. Based on some of the research we did, they've adopted those standards across the state.
Now, something you said earlier, back to the criminal side, you said when the district attorney takes a case to the grand jury and an indictment is issued, does that indictment go to you or does it go to the court?
So,
The court issued. Does that indictment go to you or does it go to the judge?
So when they leave the grand jury, once the indictment, the secret stuff happens in the grand jury room, the DA can't touch it again. It goes straight to the sheriff, to the bailiff. And the sheriff's office carries the indictments to the clerk's office. They grab a clerk and we walk together to a judge's chambers. They hand the indictments to the judge and the judge hands the indictments to the clerk.
Okay, and to be clear, the bailiff is an officer of the court that works for the judge, correct?
Works for the sheriff.
Well, I understand that's their primary employer, but they're assigned to the court.
Yes.
You're right, yeah, okay. And so the indictment goes from the grand jury, which would be the DA. It goes to the sheriff's office, from the sheriff's office to the judge, from the judge to the clerk, and the clerk enters it in the system, correct?
Enters it in the system.
Okay. And that's on every indictment that comes out of a grand jury?
Every indictment.
Okay, thank you. Anything else? Anything you'd like to add, ma'am?
No, thank you for understanding. I do want to just do a plug. I talked about the collaboration. And I really need to, it's probably a separate conversation, but I really would like to, for you guys to talk to the administrative office of the courts about the weight of these cases and how it's going, because with the case assignments coming from me, I see the numbers that are coming in, and I can't even fathom how, they manage the dockets of these type of cases. I just did it takes me, days to do a 61 defendant indictment, right? Just to process it. And so then you assign it to one judge, and then the next judge gets a one defendant case, and it's counted the same. And it's just, that part of it just doesn't sit well with me. And I'm hoping that we can have some further conversations about the weight of these cases that we have in Fulton. Even my colleagues, the clerks around the state, they can't relate to how much work that we have based on the indictments that are coming in and the work that's coming in Fulton.
Mr. Chairman, that might be a great next committee meeting testifying opportunity for us to see that, as well as getting some more of the data behind what we've learned today.
And,
thank you.
And I do appreciate that. And, I'm infected with this bluntness, and I've looked at Fulton County from a lot of different ways, and thanks to Chairman Albers, my involvement since I first was elected and came up here, looking at the judicial process, and I appreciate that. And we've looked at those formulas, and I've been in circuits, of course, that did not have 1 million citizens. They addressed 300,000-400,000. But I think as we hope that matrix does offer some relief to Fulton County, I think that you've shown some initiative that sometimes needs to be taken up within the circuits to address some of these issues. When we find breakdowns in the systems like you have with the GCIC and other things, and that solve some of those problems. And, you know, the wills that you mentioned, you know, and the judges, and then speaking to the Madam Magistrate and talking about the possibility of increasing some of the ceilings on the civil process. I think while looking at the necessary resources that we look for to increase the effectiveness of the Fulton County Judicial Circuit, at the same time, there's those little fixes we can do in there to help with that. And I've heard about the Mental Health Accountability Court and some of these pretrial initiatives that are being taken. And I'm extremely impressed with the plea out on those nonviolent cases. And so I think the last thing we need to do is sit on the bench and wait for somebody else to solve our problem, which I think, I agree with the chairman, that has to be a conversation that we need to have at one of our upcoming meetings. Please keep pushing everybody within the circuit to take the aggressive action that you've taken with GCIC, and let's solve these problems as soon as we can.
Thank you.
But with that said, I appreciate everyone being here today, appreciate the committee members being here, and we'll stand adjourned.